The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. We are here this afternoon in the matter of 3 different cases. The first 2 cases will be heard by oral argument. The third case will be submitted on the record. First case is Jennifer Morris et al. Versus Legends Fieldhouse et al. Second case is Billy Dean Carter and others versus Jason Carter. And the third case without oral argument is Johnston versus Iowa Department of Transportation. At this time, we're going to start with the Morris case, and I'd like to do a quick sound check. First of all, Justice Apple, can you hear me?
I can, thank you.
Thank you. Justice Apple is participating remotely. Let's see, we have Mr. Zenor. You arguing for Legends, is that correct? Thank you. Would you please do a sound check?
Adam Zenor on behalf of JP Parking.
Thank you very much. I can hear you.
And Mr. Stombaugh? Yes. Thank you. And would you do a quick sound check too?
Good afternoon, everyone.
Thank you very much.
Okay. You may begin.
May it please the court,
Yes. Is your microphone on?
Yes,
Okay,
sir.
thank you.
counsel. Adam Zenor on behalf of JP Parking. We are here today on further review from an application seeking relief from the Iowa Court of Appeals ruling which reversed the judgment of the district court which entered summary judgment on behalf of JP Parking. The facts of the case before the court are undisputed. They're straightforward. The facts are these. Ronald Hauser was consuming alcohol on a fall evening back in 2015 at a location called Legends Fieldhouse just west of Des Moines. That night, he'd consumed undisputed 5 to 6 beers at Legends. At the same time, or happening concurrently, we have the plaintiff in this matter, the estate of the decedent Holly, was out with his friend, a fellow called Jason Willis. They arrive to JP Parking around undisputed 11:37 p.m. That's, like I say, undisputed in the record. There's video evidence of that. They stay for about an hour and a half, at which time Mr. Holly's asked to leave. He's seen entering the entertainer's dressing room. He's walked to the front door. His friend, Mr. Willis, arrives at the front door. There's conversation, undisputed, between Mr. Willis and Mr. Holly. There's conversation then between our bouncer and Mr. Holly. He's offered a cab by our bouncer.
Is that undisputed, Mr. Zenor? Because there's a suggestion in the plaintiff's brief that maybe the cab wasn't offered by your client. Is that undisputed?
It is undisputed, Your Honor, Justice Mansfield, excuse me. At the district court, there's a 5-page statement of undisputed facts. No facts were disputed below, and it is a statement of undisputed fact. In fact, It's statement 10 on page 1100 of the appendix. And I misspoke earlier, I'm sorry, page 3 of 6.
Mr. Zenor, let's assume the same facts as in this case, except that Mr. Hawley is struck and killed while on premises as he's walking away from the building. Is that a different case? Is there duty in that case?
Well, it is a different case, and it's a different case for a couple reasons. Obviously, reason one, that is, Holly, is on premises, but also the potential, and perhaps whether it's a third-party tortfeasor, which it sounds like the hypothetical is contemplating, whether it's a drunk driver or not a drunk driver, that is also occurring on premises. So it's two things, both of which occurring on premises.
So I guess my question is why does it matter when the specification of negligence relates to the operator's conduct while Mr. Hawley is on premises? Why does it matter in terms of legal duty that he is struck and killed either on premises or off premises? So if you take this to kind of the extreme, let's assume one case where he's struck by the motorist on, 1 foot on this side of the property line, and in the other case, he's on the other side of the property line. Why should that matter in terms of duty?
Justice McDonald, it matters because that's what Iowa cases have historically held. That's one, why it matters. Two, why it matters is Restatement 40, comment F, contemplates that duty, which is bounded by place and time. And that really gets to the heart of the Justice's question, really gets to the heart of why we submit the district court's ruling ought to be affirmed here, because we have bounded by time. The technical phrase is geography, right? But by place and time, temporal and geographic.
Counsel, does it matter here that your client didn't serve alcohol, but that it permits consumption on its premises? Is that of any import here?
No, I'm sorry.
Does that change the duty or the scope of the duty that your client might have?
No, Your Honor. The duty that's set forth and that's contemplated both in Iowa case law and then that we go to Restatement 40 to see makes no distinction between a business of the nature of my client or other businesses, with the exception, frankly, schools, innkeepers. Those are cases where Iowa courts have seen and really looked at, frankly, perhaps the Cedar Rapids School District case. What we have there, if we want to really press on the nature of the business or the nature of the operator, if you will, under Restatement 40, what you have in the Cedar Rapids case, which of course came to this court, the duty finding, as this court will recall, was not preserved in that case. And there are a number of two justices on a dissent in that case that may have disagreed on whether that preservation was appropriate. That is the majority's determination on whether preservation was appropriate. But to get right to the question, there is no greater duty that's contemplated under Restatement 40 based on the nature of this particular business. What you have, for example, in the Cedar Rapids school case, is you have an in loco parentis type relationship. We've got all sorts of Iowa law that will look at and give a heightened duty to a relationship, a custodial relationship of that nature. Some of the justices on this court will have identified what made that case a little tricky or a little thorny was the status of what would be the protected party in that case. But to get to your question, no, I don't think the law creates some, or ought to create some distinction in duty based on that.
So what else could your client have done to that would have made a difference here? I mean, you had a legal right to eject him when he's misbehaving and he's intoxicated. You offered a cab. What more could have been done?
Respectfully, Justice Waterman, we submit nothing. And that goes to, Justice Waterman, your, what I read to be one of the points of the dissent in Gutters, which is the first question is the duty question, which under Restatement 7, have we done anything to create a risk? Here, no. In Gutters, some of the court said no. Here, though, undisputed facts, clean record, walk him out. He does, we've acknowledged, and we put it in our statement of undisputed facts, he does drop his wallet on the way out. That's undisputed. But what is also undisputed, Holly did not trip, fall, otherwise lose his balance. That's paragraph 12. The video further illustrates Dalton Holly speaking with Jordan Willis before walking off. And then, of course, after he's offered the cab, the district court doesn't put this colorful statement of fact in, which is undisputed and shown, but Holly actually shows his middle finger to his friend as he's walking off.
Counsel, does it matter here at all in terms of the scope of the duty that it's not within city limits, that it's sort of in a kind of more rural area, and that if this person is walking away, they're walking, presumably miles, perhaps, from any place that they might otherwise be going. Does that matter at all?
Justice McDermott, no, not under our rubric, not under Restatement 40, not under F. And of course, even if we were to look at our Mitchell versus Cedar Rapids Community School District, what's noteworthy, of course, there, if we read further in the commentary and we get to sub L, which deals directly with schools, what that commentary, of course, notes, as Justice Waterman noted in his dissent, and I'm paraphrasing, but essentially the duty here is at the school bounds. I mean, they track, and what's noteworthy about that is not that the restatement drafters think that we're going to treat schools differently. What's noteworthy about that comment is that comment makes very clear, to the extent it's already clear in the restatement, but there's a preface there that says that we're going to treat it just like the balance of the duties in the restatement.
Couldn't a case be made on, the comment to Section 40 about the duty being bounded by time and geography really relates to kind of the specification of negligence. So in the school case, to the dissent's point, the argument there was the school should be doing something off premises to monitor the conduct off premises. So that's the geography issue. In kind of the street parking, adjacent parking lot type cases where there are fights, you've read the cases, bar brawls in parking lots, we say it's bounded by geography because the owner doesn't have a duty to actually police things outside the property. But it seems like this is a little bit different because the claim of negligence, at least now, pre-discovery, whatever, or pre-trial, relates to the duty when they're ejecting this patron from the bar. And that's something they can control. It is on premises. And now maybe there's a stronger argument that as a matter of law, they met the duty. But I'm struggling a little bit with that duty question.
Justice McDonald, well taken. Would respectfully submit, I have a little different view as to whether the specification of negligence in our Cedar Rapids case is as the justice identified. What the specification of negligence there was, frankly, and you had a whole different record, by the way. We're reviewing facts that are wholly different, but those facts that we were reviewing in the Cedar Rapids case said, this is a Kennedy High School case, where we had policies and procedures established in the trial record that we would call if people were missing, tardy. That is a specification of negligence at the time. That would be similar here. Now, I see my time is short, but this is another a compounded problem, if you will, here. Here, plaintiff wants the protection, right? But he wants that protection from some negligence, which, obviously we say in the record there is just no evidence. But then he wants either, and it's unclear, protection from himself.
No, but the record says that your staff says it's not safe for him to be walking out around there with dark clothes on. Tie in. I mean, how does that tie in? I'm sorry if you didn't hear me.
Justice Apple, I did. What the undisputed facts in the record relate to is we've offered him a cab, we've offered him a ride, his friend. He's in Holly's position, but that's not the legal analysis here. And so I would say that in response to the Justice's question. The second piece, though, which really goes to, he wants to both have the protection, if he's the instrumentality, right? If he's the instrumentality, we can't get it because if we look at, and I think the court sees where I'm going here, but if it's Thompson, he can't be the instrumentality because the plaintiff ought to be the motoring public, okay? And so that's inconsistent. You can't both be your instrumentality and the person protected.
You may wrap up.
Thank you. Oh, I'm sorry, Your Honor. Thank you.
Mr. Stombaugh?
May it please the court, counsel, sorry, Justice Apple. The questions that have been placed before this court are relatively clear after the Thompson case and after the Hoyt case. One cannot but read the Hoyt case to understand what the nature of the duty is under these circumstances for a patron who is not in a position to protect themselves. In the Hoyt decision, we have a detailed discussion of scenarios where, because of the nature of the relationship and the nature of what's going on in this particular place, and a place just like this, that there is a duty which is fairly extensive. We can look at it here by showing that here, the nature of the defendant's business, patrons are consuming alcohol. That's the owner who indicates this. The aspect here is that that duty of care applies regardless of the source of risk. Okay, the presence of an intoxicated person on the premises immediately exposes the proprietor to hazards of liability resulting from the unpredictable conduct of such persons.
Counsel,
Hoyt, one, it was another patron, and two, it happened on site. And here we've got, a half a mile down the road, half hour later, not by another patron.
Right.
Do those facts make a difference?
Actually, not, because the breach of the duty still occurs on premises.
So what should they have done differently?
Well, there are a number of things that they could have done differently, and Hoyt recognizes what those were. They could have escorted him out and kept an eye on him while they called the police. Calling the police is something that the Hoyt case specifically says can and should be done.
But what crime has he committed?
The issue is not one of his criminality. Of course, he has committed no crime. In fact, he's not necessarily even misbehaving inside. What he is someone who, there may be public intox, okay? I make room for that possibility, but the issue is really one for his own safety, okay?
Aren't you assuming also you call the cops that they're going to come quickly, which I highly doubt is going to happen? They hear that they got a drunk at a bar,
Sure. Here's what
so you're going to make them babysit all night long?
Sure. Here's what we know. What we know is that from evidence from pulling the West Des Moines Police Department records for this facility, that the police officers were there within 240 to 360 seconds most of the time. This is a relatively minor inconvenience for them in terms of somebody who they know is walking off. This is not.
You may have those stats for this particular facility. Maybe there's a quick turnaround, but do you really think that's going to be a very quick response? I mean, because this case would be used in other cases down the road as an example. And all of a sudden we have bars calling for drunk people and they're calling the cops all the time.
Well, absolutely. And what we know about this is that this is nothing new. We've had this law in Iowa for 10 years. Essentially the same duty for patrons under circumstances where the patrons may not be in the best position to protect themselves. What we see here, though, is that the duty applies regardless of the source of risk, and it applies to risks arising from, in that case, Hoyt's own conduct, okay? Because this is the kind of business that they run. They know this. They know the type of people who are going to be there, and they know the circumstances of where they are and when they try to leave. But in this case, this isn't somebody who silently walks off into the night. This is someone who is taken from a position of relative safety inside, okay, placed into a position of relative danger. And that's also talked about in the restatements when you're talking about moving someone, when the person acts to move someone to a more dangerous place where they could be
Do you
exposed.
concede that they had a legal right to evict him?
They had a legal right to have him leave the premises consistent with what they knew. This isn't, as I was starting to say, Justice Waterman.
Can you stay by your microphone so
I'm
Justice
so
Apple
sorry.
can hear you?
I'm
That's
sorry,
okay.
Justice Apple.
I'm doing fine, thanks.
Okay, so what I was about to say, I think is quite relevant here, is that they remove him from that place of relative safety, and he didn't just walk off into the night without people knowing this. There was a decision made. They were observing that situation, and we have somebody who may not be making the best decisions for their own safety.
Can you address comment F to section 40 of the restatement, which does seem to indicate that the duty issue can be resolved and it's limited by time and geography?
Well, what I know is from Thompson, which applied it, the Thompson court said that the proximity between the breach and the injury is based largely on concepts of foreseeability, which is highly fact-dependent on the case. What we know here is that what the defense is arguing is that the issue is proximity to the place, but we know tort law is full of instances, even in a medical negligence case where a surgeon chooses the wrong size screw, and yet it's the hip that fails in a pool in Puerto Vallarta. Well, there is clearly a distance here, but it's the decision and the breach of the duty that occurred on the operating table. It just shows up farther away. So,
And I can't recall that the injury in Thompson was not on the landowner's.
No.
Was it the trampoline had blown off into the street,
it
correct?
had, Your Honor, and that was the case. And in every one of these situations, and in fact, the circumstances referenced by the district court all involve a mix of foreseeability and trying to decide when and where the breach happened. Every case that we have in Iowa that is about breach, is about proximity, and is about damages are all jury questions for that reason.
But duty's a question of law.
It is, and the district court acknowledged that there was a duty.
So should we consider the policy ramifications? Judge Porter mentioned the possibility that if a bar, if their choice, if the cabs refused what to hold them for the police, could a business fear a suit by the person they're detaining for false arrest?
Well, I think that is to some degree, a ridiculization argument made by the defense of a situation which this person was not going anywhere until he was removed. That is a situation which was decided and chosen by Mr. Kramer, who is the person who eventually just
I don't
watched
think
him.
that's so ridiculous. He was removed from the building, and they weren't going to probably let him back in. But you're saying they shouldn't have ever let him go. I can't imagine that person just idling and allowing them to literally or physically hold him tight. I don't think that's so ridiculous.
Well, what I mean by that is that the issue is one of when we're talking about. Here, when he was there and present, if they made the decision that he's going to need to go,
Well, counsel, what if it was the end of maybe it's closing time and everyone has to go?
absolutely.
Does the same duty apply then?
The same duty applies at all times, but it is bounded not merely by physical geography, but what the facts are. What did the people who are running this establishment know about this individual and what his condition was at the time? What they said is,
So every bar has to do an assessment of every patron that leaves as they leave to determine whether or not they can safely leave on their own?
I'm not saying that that's the case, but what I am
Or
saying,
maybe they're going to all say, I know nothing, I see nothing.
well, the
Sounds like a
sergeant
jury issue.
Well, Your Honor, what this is, in fact, the district court cites that case that small changes in facts can lead to wide discrepancies in how people will observe those. That becomes, in fact, a jury issue, although that part of the quote was not cited by the court, but that's the rest of that quote, is these small.
Mr. Stombaugh, what I'm hearing you say is that depending on the facts of his condition, there might or might not be a duty, is that right?
No, the duty is there, but how that duty works itself out has a lot to do with what they know about the situation. In this case, we have knowledge that he is simply being allowed to walk off under conditions where even the bouncer is like, this isn't safe. He doesn't have appropriate wear on. Something bad could happen here. And getting back to your analysis, they didn't know the other person. But most of the circumstances in Hoyt involve something which is recognized. And what Mr. Kramer recognized on behalf of Beach Girls was that there is a generalized danger for this person to be encountering. And in fact, the driver who was coming to Beach Girls after bar time. This is not an unknown aspect here. Mr. Hauser was on his way and spent the rest of the evening there after he killed my client.
Justice McDermott asked a question earlier about the location of the bar and whether that made a difference. So in this case, if let's assume it's downtown Court Avenue, Des Moines, and he's ejected from the bar, is that a different case in terms of duty, scope of liability, and breach than this case, where as I understand it, it's in a relatively rural area and he has to walk on a highway?
Like every one of these cases, the issue of duty is the same. How one discharges that duty has everything to do with the circumstances. Those circumstances are always jury questions.
Well, let me ask a question. Let's say we had somebody in this building, maybe somebody watching this argument, and they were misbehaving and they were clearly intoxicated, and we had them escorted out, and the person's clearly intoxicated, and then somebody ran over them over on Court Avenue. Would we owe a duty to that person?
The scope of that duty, okay, will vary depending on the nature of the relationship. In this case, we have somebody who is there. The question is, at that time, is an actor, even this court system, would have.
But I mean, Humor me, give me an answer to my hypothetical. We've invited the public in. Somebody is in there, in here, they misbehave, as did Mr. Holly, and they're escorted out. Say by, like one of those gentlemen.
Other than purposes, without looking at potential governmental immunity issues and otherwise, it has everything to do with what was known by the officials and what they knew at the time. And if this person was so intoxicated that they could be a threat to themselves or others, that is something that would figure in.
Well, let me ask you
you.
the same question that I asked Mr. Zenor. Does it matter here whether they were actually serving alcohol or whether they were permitting alcohol to be consumed there?
No, it doesn't, because it's essentially creating the same environment either way. I mean, the language in Hoyt is that, a bar and this strip club, it would be a business venue in which alcohol-fueled disturbances are happening.
You didn't sue them for dram shop liability, correct?
That's right.
There was another defendant that was sued under that theory.
Exactly.
If liability is similar, at least if there are sort of similar points to be made, that it doesn't matter whether they're serving or not, I guess, how does that play into the duty that's owed?
Well, I agree with counsel for Beach Girls that it doesn't make a practical difference, but I will tell you why it should, additionally why it shouldn't, because even their owner indicated that the consumption of alcohol is an important aspect of their business model. That's what's happening there. They want those folks to be.
But, the Iowa legislature made a policy choice not to recognize social host liability, or even in DRAM, the estate can't recover for, the drunk himself can't recover for his own injuries. It's just the victims of the drunk, except for maybe loss of support.
Right.
Should we consider that in our duty analysis?
Not here, because this court has already assessed a situation where there is a duty, and what to do about it.
In what case have we said the duty applies to a business that ejects somebody when they're hurt somewhere else, by somebody else? I mean, this would be the first time, right?
Well, actually, I think that is a fair reading of Hoyt. The fact that
Hoyt's by a patron in there, they saw the trouble between them in there, and then it happened on the parking lot. Arguably, they should have done more to keep the peace in their own parking lot. But this is one guy walking away, half mile later, 30 minutes later, he gets hurt. Where would that duty end?
Well, the duty has already been breached. You can't call back the duty once the duty has been breached and the action has been set in motion.
So you're saying it was breached by allowing him to go?
No, it was breached by moving him from that place of relative safety to a place of relative risk and danger.
By letting him go, by letting him start to walk?
And then by simply letting him go under these circumstances when they knew he was not in a position to self-protect.
Doesn't that mean then, but you about have to say to the owners, you have to force them to stay?
No. The aspect here is merely keeping an eye on him for the 360 seconds it might take for West Des Moines police to get there under the circumstances of this case.
Yeah, I'm going
It's not
back
too
to the
high a
rural
burden.
communities where that doesn't happen. That
Okay,
doesn't happen.
And I appreciate that may not happen everywhere, but ultimately here, we have a situation where they were quite aware of what the dangers were to him, and they let him go anyway. That's not merely somebody who's just happened to be there and didn't have any notice. He has been ejected and he's put on the road. And once he's out of their driveway, which took almost all the way to get there, he's even he's going in the wrong direction for his hotel. He is clearly in a position of somebody who needed the protection of the restatement, and the restatement in the Hoyt case allows for that, and that's part of their duty. You have to be able to, you are only being charged.
You can wrap up.
Yeah, sure. You're only being charged here with what your knowledge is of this situation. They happen to have a great deal of knowledge about the dangers facing here. Your Honors, relative to the cab issue, if I could address that very quickly. Am I out of time?
Yeah, you are out of time.
Okay, then I will be done.
Thank you.
Thank you so much.
Mr. Zener.
I'm sorry, your mic isn't on, Counsel.
Thank you, Justice Apple. To
Yeah.
Chief Justice Christensen's point, this, the paradox of the appeal initially in the routing statement says that the plaintiffs in this case believe their case is a case for established Iowa law. To what I understood was Chief Justice Christensen's question and/or Justice Waterman's point, this case would be a dramatic expansion of Iowa law found nowhere in the case law, rooted nowhere in, to Justice McDermott's point, could you briefly address Restatement 40, Comment F? In all of the briefing, down to up, District Court, Court of Appeals, Supreme Court, plaintiffs have not addressed Restatement 40, Comment F. Today was the first day in any of the ink that was spilled, well over 100 pages, that they attempt to address that. And it goes back to the court's question about this, the unworkability of some rule. Here.
Well, of course, Thompson was off-site. If you're saying, I mean, the fact that the accident happened off premises, that's not anything terribly new.
Respectfully, Justice Apple, Thompson's off-site, but that's an instrumentality on premises that goes off premises that's owed to the motoring public.
Right, and they say...
I'm sorry, Justice.
No, go ahead.
That's Restatement 54.
But they're saying the wrongful conduct occurred on premises, just as the wrongful conduct in Thompson occurred on premises too, actually.
Correct, but the duty to whom that conduct is owed is different and incredibly important. This is not a Thompson case. Thompson involves an instrumentality, an artificial condition on the land, which is blown from the land, to a plaintiff who is a motoring public. Restatement 54, and in the comments, addresses, that's a Thompson case. So the fact that the injury does occur off premises is absolutely critical, because it goes to, one, scope of liability. It also goes to whom the duty is owed.
Well, I don't think that makes any sense. Supposing the accident had occurred, supposing you have a large parking lot and the accident occurs just inside the parking lot. Is that materially different than an accident that occurred 10 feet off?
The comment about whether it makes sense or not is respectfully for the restatement drafters. The comment as to as the other justices have noted, whether it's just on or just off the premises, goes to Restatement 40, Comment F, grounded by geography and time. Those hypotheticals, you're talking about moments. You're not talking about, we've heard half an hour today, the undisputed facts in the record are 56 minutes, much closer to the hour. So you're bounded by geography and time. On this undisputed set of facts, which I have to respectfully say, we've heard a number of other facts today that were not adduced and were not properly supported before the district court. This notion of police reports, it must be under 19815, admissible evidence. It isn't. Plaintiffs didn't carry their obligation before the district court. We've been here before, excuse me. I'd respectfully submit that plaintiff must carry their 19815 obligation to not come here with, in order to create a workable rule by facts that are not properly.
I want to explore the on-premises, off-premises distinction a little bit more. And I wonder, in light of Thompson and the way we think about this, if we should be rethinking whether that distinction makes sense where the conduct occurs on premises. So and Justice Apple touched on this, we have cases indicating an establishment could be liable, for example, ejecting somebody from a bar when it's freezing cold and the person freezes to death. And so should the basis for liability or duty really determine on whether or not the patron manages to walk across the property line before succumbing to the cold and then dying? I mean, it just doesn't seem like that tracks with the notion of duty. And again, maybe other issues relating to liability, causation, et cetera. But in terms of the legal duty, I'm not sure why it matters where the plaintiff ultimately dies.
Thank you, Your Honor. Justice McDermott, it goes back to what I understand to be Justice Waterman's, a couple of Justice Waterman's points in his writings. One, with respect to duty, what was done that created the risk on these undisputed facts? We submit the record has nothing. The court's hypothetical is very different. Those would be very different facts. Two, what has then been done to increase the risk? If there's been a risk created, what I read to be a duty question, then is that risk increased? Then that's a scope of liability question. Here, on the undisputed facts, there's nothing. There's nothing to the court's question earlier about their proposal now, years later, is call the police. Because what? There is nothing, and so respectfully, Your Honor, I think the hypothetical is very different that the court's offered versus what the undisputed facts are. In this case, the court may fashion a bright line rule, as has been contemplated. It may do something short of that.
You may wrap up.
Thank you. It may simply find that on these undisputed facts, there is no duty. It may do something short of that. It may find duty, because again, we've heard that the district court found no duty. No, the district court found there was a duty. It just found the duty ended at the end of the scope of liability. And so this notion that the district court sort of missed the ball, I'd respectfully submit is in error. And finally, Your Honor, due to public policy considerations, that's another reason why the court should affirm Justice Porter's ruling.
Thank you.
Excuse me, Judge Porter's ruling.
The case of Morris versus Legends Fieldhouse et al. Is hereby submitted. We'll take a brief break while counsel from this case gathers their belongings. We'll do a really quick sanitation, and then lawyers for the next case can take the tables in a moment. Thank you.